Okay, so we ask that you mute yourselves now and continue to stay muted throughout the workshop unless you are asking a question during the Q&A. I also want to remind you that this event is in meeting format. That means you can see and hear everyone in this meeting, and everyone can see and hear you as well. This workshop is eligible for 1 hour of MCLE credit and 1 hour of MC3 continuing education credit. If you are requiring MCLE credit for attending this event, please make sure that the name that is displayed for you during the workshop is the name that matches your state bar name. It does not, if it does not, please change that now. If you did not provide us with your state bar number during registration, please email us. The webinar is also being recorded. You will receive an email sometime next week with the recording along with the attendance form that can be used for MCLE and MC3 and a survey of today's event. If you have any questions, please email me at info@scme, scmediation.org. I would now like to introduce Stephanie Dobson.
Did you want me to go ahead, Taisha? Or I
Yes,
didn't want
go
to
ahead.
cut you off.
Sorry. No, go ahead.
Go ahead. Okay,
Mhm.
perfect. Well, hello, everyone. My name is, I'm just going to put everyone onto the right screen so I'm looking at everyone. My name is Stephanie Dobson, and I am a lawyer and mediator from Lloydminster, Alberta, Canada. Where for the past 2 weeks it has been, I looked it up, it was minus 50 in centigrade, which is minus 58 degrees Fahrenheit. It's lovely these days. It's all the way back up to 0 degrees, so we're in t-shirt weather around here. But it's very nice to meet you all, and I'm very excited to introduce to you a project that I've been working on for the past, well, it's now 12 months. I was going to say 11 months, but it's now been 12 months. It's called Up a Notch Learning Inc. And the easiest way for me to show you the platform that I've created is actually to screen share and to show you what I've been working on. So let me do that now. All right, I am going to share this screen. Now, I'm just trying to think what you should be able to see is my website. Is that what you can see?
Yes.
Yes.
You can. Okay, thank you. I've got 2 screens going, so I just needed to make sure I'm on the right screen. Okay, so this is called Up a Notch Learning Inc. So we are an e-learning community supporting separating and divorcing families as they go through their transition into 2 homes. We support families in one of 2 ways, either direct to families, where we've created an e-learning community, which I'm going to show you in just a moment. And we also support and reinforce the work that divorce professionals, lawyers, mediators, therapists, financial advisors do with their clients. So to get access into our community, you click on up here where it says join free. I've already opened the window on another screen here. So that will take you to a screen where you simply put in your first name, email address, and you create a password. Once you click sign up for free, that's going to take you to over here. I've already logged in here on the other screen. That's going to take you into our e-learning portal. So right in here at the very front, you're going to see a welcome video from me, as well as all of our resources in here. They're also located on the left-hand side of our screen. The courses are premium courses, so they do cost, and I'm going to introduce those to you in a moment. But what I wanted to focus on was all of our free resources. I'm very excited because we have a few people who are at the conference who are actually in the seminar today who either have or will be doing interviews with us. So in our interview series, we do things like I've interviewed people like Dr. Larry Waldman, who's a psychologist talking about second marriages, Alexa Turner, who's a lawyer talking about billing and what people can expect with billing. Jacinta Gallant, she's one of the attendees who's talked about going deeper, digging for the pain points and why that's important. Gary Dernfeld, who's a registered social worker in Ontario, Canada, who talks about the importance of having a therapist help. Rebecca Fisher, who talks about children with special needs, and Tabitha Mizrahi, who's an educational consultant, talking about the importance of liaising with the schools and how that can help your children to thrive. Michelle Charles Gustafson talks about confidence journey, and Coach Tara Dawn talks about divorce wellness. Our last two interviews that we've got loaded, Harpreet Christie talks about, is a realtor who talks about using a realtor in a positive and constructive way for things other than just selling your home in a divorce, and Holly Brady, who is a CDFA, who talks about using them to help in divorce settlement negotiations. So that's our interview series, all completely free to anyone who joins our site. In our book club, I've so far got 3 loaded, and my goal is to do 12, so 1 a month, and my goal for interview series is to do 1 per week in all of 2020. So by the end of 2021, I'm excited we'll have hopefully 52 interviews up there. So we talk about some books that are positive and constructive books for divorcing families, figuring out to stay or to leave, Mom's House, Dad's House for Kids, and Mom's House, Dad's House, the Adult Encyclopedia. Our book library is getting very full. If anyone has ideas of books for families to add to our library, we'd appreciate it. We've got books for kids, personal journey, relationship breakdowns, parenting after separation, process options. We've got all of Bill Eddy's books. We've got Bruce Fredenberg and Carol Hughes' book in there. Of course, I know they're attending today. I'll just give you an example here. The kids library, we've got Amazon links for all of them. And this is of course a resource for parents to figure out how to best help their family as they transition into 2 homes. I've got 1 ebook loaded here. It's for helping families to learn how to communicate. You just click on it and it will automatically download. I've got some blogs, Q&A, and then we've got our list of contributors. So the last part I want to show you, I know my time is limited here today, is the courses. So these are the premium courses that we have on our site. So I've only got 1 full course so far. It's called Healthy Thriving Families 101. And that's made up of the following modules. You'll see divorce mission statement, the spectator gallery, talking to the children about separation, finding the right process and the right professional. I've got my top 10 tips on preparing to untie the knot and divorce wellness. These courses are each $15. The modules themselves are $15 to purchase, or the entire course is $97. The reason I like to do it module by module is my goal is to meet families where they are and to have them to gather the information that they need, whether it's an entire course or just modules or an interview here or there or some books. I just want this to be a community resource for people to gather really great information that's all positive and constructive. We know the Dr. Google challenges of some of the destructive information you can get. So that's my tour. I'm just going to stop the screen sharing now. I can figure out where the stop screen sharing is. Taisha, can you stop my screen sharing? Oh, there we go.
No.
Okay, there.
Yeah.
So the last thing I just wanted to mention is one of the beauties about attending a seminar like this is there's so many amazing professionals, and I love to connect with professionals. If anyone has ideas to add more resources to this website, to my portal, please contact me. If you go onto our website under divorce professionals, there's a contact form, and that gets direct to me, or you can email me, Stephanie@uppanotchlearning.com. I certainly encourage you to take a peek at it. I know I'm going to be interviewing Bruce Fredenberg and Carol Hughes upcoming about their book on gray divorce. So I'm very excited about that. So that's all I wanted to say, and thank you so much.
Okay. So thank you, Stephanie and Up a Notch
Mhm.
Learning for supporting this year's Family Mediation Institute. I would now like to introduce to you our workshop host, Lynette Kim.
Lynette, you're on mute.
Sorry, thank you. Good morning, everyone. As I was saying, welcome to this workshop, Modern Love, Innovations in How We Address Family Conflict. And I welcome everyone. I would like to introduce the two presenters this morning, Miss Sarah Gross and Yane Barroso. Sarah Gross is an attorney licensed in California and a trained mediator with expertise in multi-party family dispute resolution. She is also a published author and educator with publications in various journals, including the Orange County Lawyer, Nursing, and the USC Interdisciplinary Law Journal. Ms. Gross received a master's degree in education through the University of California at Davis and taught high school and middle school English prior to entering law school at Chapman University Fowler School of Law in Orange, California. After completing law school and becoming a licensed attorney, Ms. Gross completed a Master of Law at the Strauss Institute for Dispute Resolution with a concentration in elder care dispute resolution. She spearheaded the development of a pilot program in elder caring coordination in Orange County, California courts, and has educated and trained the Orange County legal and mediation community in elder care dispute resolution. She has also presented at various venues, including the Southern California Mediation Association Annual Conference, the Orange County Bar Association, and the American Bar Association Dispute Resolution Conference. In addition to mediation, she continues to publish articles on topics related to law, dispute resolution, and education, as well as offer webinars and trainings. Yane M. Barroso is a founder and attorney at Barroso Law, PLLC. Focusing exclusively on marital and family law, Yane Barroso combines over 11 years of hands-on experience with passion and dedication to her local community. She frequently represents clients in multifaceted matrimonial matters of law and has proven practice in dissolution of marriages, equitable distribution, adoption, and LGBT family law issues. Ms. Barroso is incredibly passionate about helping families navigate their way through marital and family law matters and is knowledgeable and understanding of contested cases concerning paternity, enforcement and modification proceedings, alimony, child support, time sharing, and parental responsibility. An active advocate for historical preservation of her Key West hometown and the Florida Keys community, she was awarded the Florida Bar Animal Law Committee's Outstanding Service Award on behalf of her work to draw attention to the endangered Florida key deer. Through her published work in the Florida Bar Animal Law Committee newsletter, she gained the attention of the United States Congress. This led to the installation of signage along Overseas Highway US 1 to generate community awareness for an endangered species of deer symbolic of and native to the Florida Keys. In addition to animal advocacy, she is a dedicated member of the Florida Bar Family Law Section, Monroe County Bar Association Pro Bono Committee, and the Rotary Club of Key West. Through compassionate care, clear communication, and excellent detail, Ms. Barroso dedicates her time to serving the needs of families in her hometown of Key West and throughout Monroe County. And with that introduction, here is Sarah Gross and Yane Barroso.
Good morning. It is wonderful to see so many of my mediation colleagues here. Thank you, Stephanie, for the introduction to Up a Notch, and thank you, Lynette, for the introductions. Tina and I are very excited to bring you this workshop about innovations in how we resolve family conflict. Just a couple of logistical issues. This format is going to be partially lecture style and information and partially interactive. During the lecture portion, if you could stay on mute, that would be helpful. But feel free if you have any questions or comments throughout the presentation to put them in the chat, and we will do our best to answer them throughout. In the second half, it is an interactive portion where we'll be discussing a couple of hypotheticals. And you should have received in your materials 2 hypotheticals that we'll be looking at in terms of issues in family mediation that we see now and how we may address them as an advocate or as a mediator. So hopefully you have that in front of you, but we will be going over those 2 hypotheticals once we get to the interactive portion. And during that portion, I encourage you and I hope to see you interact. You can either do that in the chat or you can go on, take yourself off of mute to interact in that way. So with that, I'm going to go ahead and share my screen. Okay, you should be able to see that. Okay. I'm going to try to get this onto slideshow for you.
Down the bottom on the right, on the left of the slider.
Let's see. I think we're good to go. Yes. Okay. All right. So in this workshop, we are really discussing current trends that we're seeing now and how we can more effectively, as advocates or mediators, resolve these new trends that we're seeing in family mediation and family conflict. So we'll be discussing a few of the 2 primary trends in regard to that. As Lynette mentioned, I am an attorney mediator and I'm also an educator. I have focused on multi-party and whole family conflict resolution. And this is my contact information here. So feel free to reach out and email me here if you'd like. And then Yanae works at Barroso Law in Florida as a family law attorney. And this is her contact information below here as well. So feel free to reach out to both of us or either of us if you have any questions following this presentation, or if you would just like to reach out with any comments or advice or anything in that regard. So in terms of what we hope to accomplish today, what we hope that you get out of this presentation, here is at the end what we hope that you will be able to do. Define modern love in the context of family mediation and what that means. Explain strategies in communication and conflict resolutions for the new trends in family mediation. And finally, discuss and deconstruct 2 family law hypotheticals and equip you as practitioners with tools and takeaways to navigate these new and current family law dynamics. So as I mentioned, we are seeing now 2 primary trends in family law and mediation. And the first is millennial families. So we'll discuss a little bit about what does it mean to be a millennial family, what does that look like, and what additional new conflicts does that present, and also multi-generational families. And with both of these trends, we see all of these aspects coming together now. So we now see an increase in family dynamics and new family dynamics that may be emerging. Multiple interests are now at play, various issues, not just legal issues, but non-legal issues as well. And always in the background, we have law. So in the background of all of these cases now, whether they're millennial families or multi-generational, we have the law in the background. And so we're asking ourselves, how do we now navigate these issues while taking into account the law, but also taking into account the family dynamics that arise, the multiple interests that are at stake, and all of these other little various issues, which we'll see later on, that often crop up in these new family dynamics. And we'll start with millennial families. And I'm going to go ahead and turn it over to Yanae to discuss that.
Hi, everyone. Yanae Barroso. Thanks for having me. So let's talk about what is a millennial. How do we define a millennial? Well, millennial is a person who's born between 1980 and 1994. I exclusively practice family law, and most of my practice I deal with divorces. So I'm going to stick with some divorce statistics for purposes of today's topic. So the average couple going through their first divorce is about 30 years old. And 60% of all divorces right now involve individuals between the ages of 25 and 39. So an individual who was born in 1980, for example, is about 41 years of age today. And an individual born in 1994 is about 27 years of age today. So about 60% of all the couples going through a divorce right now are within this millennial age group. And that is why we think it's such a relevant topic. And we're so excited to present that to you today. So let's talk a little bit about what issues and conflicts millennial families present. And I think in order to discuss those issues, I think we have to first understand the characteristics of a millennial and better understand them. So the first is that they want instant gratification. And I say this being a millennial myself, I'm guilty of it. We are the tech savvy generation, and we are used to having information available to us at our fingertips, achieving tasks quickly. I mean, if you want to wake up and check the weather quickly or your bank account, it's literally at the tips of your fingers on your cell phone that you can do that. So I think that carries over a lot into other aspects of our life, including if you're going through a divorce process or a family matter. The second is that we are tech savvy and socially conscious. The millennials being the tech generation and being the first generation to have access to social media and adopting it as their main communication, I think that can be used as a double-edged sword, so to speak, especially in family matters, which we're going to get into in a little bit. And the third characteristic of a millennial is that they are financially conscious, which is contrary to popular belief that they're not. Forbes magazine recently named this generation as one of the most money conscious generations, using tech savvy apps to track their spending and budgeting, and they're very aware of their financial status and financial goals. So let's break these down and talk about what each of these characteristics present to litigators and mediators in family law for so to speak, issues. So the first is this instant gratification. We've all heard that the wheels of justice grind slow, and I know that is particularly true in my jurisdiction in the Florida Keys, where there's very limited judicial resources available. So if I've got a client who needs a court date immediately, it's nearly impossible. It takes several weeks or even months. Putting aside obtaining a hearing date, there are also some procedural things that we have to go through in every family law matter that take some time. So in my county specifically, it takes about 1 year to 2 years to get a divorce, to see you through that final judgment, final divorce decree. Once a case is filed, there immediately begins a 45-day, I should say, once the case is filed and the other party has received proper notice that the case has been filed against them, a 45-day deadline immediately goes into effect. And this is a process for both parties to gather their financial disclosure and exchange them. And we call it here in Florida mandatory disclosure. And it is mandatory, hence the name. So we cannot get around that. So at the end of that 45-day process, both parties should have the financial disclosure from the other. And this is bare minimal disclosure. So oftentimes, it's, especially if you've got a case involving a lot of assets and liabilities, it's not nearly enough disclosure in order to get the case resolved. So you've got to go through other steps and perform additional discovery, which carry with them other deadlines in excess of 30 days or more. So just to get through some of this financial disclosure, you're looking at almost 90 days out, and you've not even covered or touched or resolved upon any other issue of the case. And I've noticed that my millennial clients in particular have a really difficult time with this. I mean, they want to get in and out, they want to get their divorce, they want to achieve and resolve their issues and their goals and be done with it. And that's just not the case. So I think that is what makes mediation such a desirable aspect in family law, is kind of saying, okay, look, well, if both parties agree, maybe we can shorten some of these deadlines and timeframes and get you both into a mediation and resolve maybe some of the issues or all of the issues. And I think that that gives millennials a feeling that they may have, you know, at least accomplished some bit of instant gratification in that regard. So number 2, millennials are a tech generation. 75% of millennials prefer texting over talking, and 88% of millennials use social media in their everyday life. So I think if there's 2 issues here that we should be mindful of as litigators and mediators. And the first is that there's an evidence problem. So if you've got a millennial client, we know they love to text. Well, in our world, that's written communication that can and will be used against you. So this can be both a blessing and a curse depending on which side you're on. Well, if you've got a client on one hand who is trying to prove the behavior, a bad behavior of another party, or if you've got a client who's trying to prove that maybe their spouse is working and their spouse is on social media showing that they've got this new job and that they're working, then this benefits you, both the use of social media and the text messaging evidence. On the other hand, if you have a client who is maybe a little more emotional or temperamental, maybe had a momentary lapse of judgment and send some damaging text message to the other party, again, that could be damaging to your client and definitely inflammatory to the process, especially if you're trying to resolve the case and not go down the litigation route. So as a family law practitioner, at the very beginning of every case, I like to make my client very aware of these particular issues, guide them through the process, let them know that text communications can be used against them, be very careful what they say on text message to the other party or their children. And same thing with social media. I ask them to limit their use of social media. I know that since it's such an integral part of a millennial's everyday life, there's that constant need to overshare every occasion, whether it be that new job, new relationship, you know, that vacation that they're taking. And that, again, can be very inflammatory towards the process and kind of derail some type of resolution. So I think as both mediators and litigators, this is something to be mindful of with your clients. And the third is financially conscious. So you may say, well, what's the problem with that? Well, 56 million millennials are in the United States workforce right now. So it's not necessarily a problem to us as litigators and mediators, but for the millennials, it can be a problem because litigation is so expensive and they're financially conscious. So while they may want to get their issues resolved or even litigate them to the very end, they don't want to pay for it. They don't want to, you know, expend all of their savings, all of their earnings and hard work towards litigating, which is another way that I think mediation becomes very attractive to the millennial age group. According to Better Money Habits and Millennial Report, millennials are proving that they are just as good or better than older generations when it comes to money management habits like saving and budgeting. And they take up more than, as you can see, half of the United States workforce. And they're working hard, saving towards their goals, towards buying a house, contributing to their retirement accounts. And a lot of millennials have significant amounts of student loan debt that they're paying off as well. So they're not necessarily wanting to take from those things and pour it into litigation. I see a big shift from prior generations as well, like the baby boomers, where you've got the men who were the primary breadwinners. And millennial relationships, both parties come to the table very educated and career and goal oriented. You've oftentimes got two breadwinners. So they're both equally motivated to kind of save, and they're conscious about what they're going to spend money on. And I think that's an excellent way as litigators that we can, and mediators, guide them into a mediation setting where they can better resolve their issues and maybe not expend as many of their resources.
Now, thus far, we've been discussing the kind of the two-party scenario where there's potentially two people who are divorcing or two parents. But imagine now how these issues become even more magnified, where we have multiple adult figures having all these issues, whether that's divorce or parenting issues. And a great example of this occurs in California, and this is called the third parent scenario. Now, this is a new type of dynamic that has come up in the recent years in California. Not a new dynamic in terms of we've never seen it before, but from the court's perspective, it's new in terms of the court and how they now want to deal with this scenario. So this is what that looks like. So we have biological mom of a child, perhaps biological mom's ex-wife, and biological father. So ordinarily, biological father and biological mother are the parents of the child. So they would be deemed the parents. But what if there's a scenario now where ex-wife wants to assert some sort of parental right over the child? In this scenario, this is based on actually a 2013 case in California in which bio mom and bio dad were not married, but instead bio mom was married to wife, divorced wife. These three adults still had an intact relationship, however. And because of that, they were able to argue in a court petition, well, bio dad and my ex-wife equally contribute to raising this child, and they equally want a role in this child's life. And so seeing that dynamic and seeing that all three adults were in agreement with wanting to be involved and raise this child, the California legislature passed this family code section. And essentially this works, as I mentioned, where there's three parental figures now of a child, and there's an intact family. So where the California courts can see that there are three adult figures who are in agreement with wanting to raise the child, to do what's in the best interest of the child, then the court can say, well, okay, we're going to grant this third parent equal parental rights over the child, access to the child's records, input into decisions regarding the child, whether that's health, schooling, etc. So this legislative code now allows for more than two people to be declared a parent of this child. This may seem unusual and novel, but more and more often, especially with this millennial generation and people getting into relationships and then breaking up, getting back together, and then often other people coming in, we are likely to see this dynamic become more and more common. And likely to be seeing these this family code section be used in the California courts. Now, this is still a very new dynamic for the court system. Here in California, we've made many positive strides in terms of innovations in how we deal with family law and family conflict. The courts are pro mediation, for example. They're always looking for creative solutions to resolve family issues with collaborative courts even. But use of this family code section is still quite novel. And so we're likely to see with more millennial families and more non-traditional family structures, we're likely to see this come into play more commonly than we have thus far. And so the question is, as attorneys and mediators, how might we address this? And how might we address a scenario where there is a fourth parent? That might seem even more unusual, but with the trend in these whole family parties and whole family dynamics, where multiple adult figures now may want to have input into raising this child, how might we resolve a scenario where now more than three people want access to the child information, want the ability to have their input and voices heard as to decisions regarding the child? So this is now a novel and new issue for us as family law practitioners to think about. Perhaps the court can't resolve this if there's more than three people. So as mediators, how can we step in and help the family work through any kind of disagreement or issues they might have and essentially come to an agreement regarding their roles in the child's life?
Sarah, if I may interject at this point, we have a question.
Sure.
Can the Family Code Section 7612 be used in guardianship cases?
Ooh, that is such a good question. So far, not yet. It's only been used in the classic family law cases where it's a parenting custody issue. I have not seen it used in guardianship yet, but I I would like to bet that it will be used there soon. That is such a perfect, ripe area for it to be applied. And I really hope to see that used in guardianship more often. Moving on to now strategies. So we've talked about millennial families and the issues that arise with the millennial generation. And so now let's talk about how we can apply strategies to help these millennial families resolve their conflicts.
Okay, so since millennials are the tech generation, I always encourage my clients to use Google Drive or a similar program to share with me their financial documents. It's a safer way to share documents. It also is earth conscious, it saves paper, and it can also save them money because if they can upload it to the drive, organize, then that's less work that I have to do and charge for. Another program I like to use is My Family Wizard, which I don't know, that may be used out in California as well. It's very popular here in Florida. And it's a way for parents and even the children in these families to communicate with each other. And going back to what I said previously about kind of monitoring, if you have a case where it's appropriate, monitoring the parties' communications, this allows the lawyers to monitor the communications between the parties and make sure that everyone's acting on their best behavior and, you know, everything's going well. So those are the two technology apps that I like to use in my millennial cases. Of course, it applies to other cases as well, but it's very desirable to millennials.
Now thinking about the multi-generational family. And when we say multi-generational, we mean a whole family dynamic. So we have people in this scenario, for example, who may be of the millennial generation. We may have older adults who are of the baby boomer generation. So in a whole family context, you often have people of multiple generations who now are enmeshed in conflict or disputes, and who are presenting various different issues that need to be resolved. And so necessarily our approach to resolving those issues will depend on our ability to be flexible in how we resolve conflict. So in terms of a mediator approach or a collaborative approach, flexibility is key, as I mentioned here. Now, flexibility, when I say flexibility, I refer to flexibility in terms of the process and the way we communicate. So there are various ways in which we may conduct a mediation or a consultation session. One of them is a facilitative approach. So facilitative is where we focus on the parties' interests. We encourage the involvement and the participation of everyone in the room. We allow the process to be flexible. We adapt as necessary. And we're not as structured in terms of what needs to happen next. We kind of allow the process to be fluid in that way. And we are really guiding the practice towards helping the parties come up with their own solutions, and we're just guiding that process for them. We may in turn then turn to an evaluative approach where we may be more structured, we may be more regimented in how we want to resolve the issues. But with these multi-generational dynamics where everyone may have different preferences, where they may need accommodations, we often have to be flexible with our process and shift when needed. Another way to be flexible is to change the focus away from the glaring issue, right? So oftentimes in these cases, we have a surface level issue, and that might be the divorce, that might be the parenting arrangement. But what are the issues underneath that? Is child safety and comfort a concern? Is whole family communication a concern? So always looking to the underlying issues, not just the surface level issue, in terms of resolving these often various and different issues that come up. And then another thing to think about is in all of these cases, regardless of whether they are divorce cases, child time sharing or child custody cases, or a myriad of other family law issues, we need to know as family mediators that we're dealing with not just the legal aspect, and this is what I touched on before in terms of the legal background. We're also dealing with economic issues, with co-parenting issues, with the community in terms of the whole family community and how people relate to one another and get along, and then the emotional aspect. So a lot of conflict in these cases is triggered by intense emotion. So being mindful of the emotional state of all of the parties and helping them navigate the emotion that is coming through all these issues. And then along with that, the psychological component. So we know dealing with families and family conflict, there is often a psychological aspect to the conflict. And so just being mindful of all of these different dimensions will help us be able to communicate more effectively when we have a multi-generational or non-traditional family structure in place. So now we're actually going to turn it to our case scenarios, our hypotheticals. And this is where you will have that handout. If you don't have that in front of you, we are going to be just going through the facts quickly now. But if you do have that available, I encourage you to have that next to you or pull it up on your screen. And again, that's the handouts. And this is going to be hypothetical number 1. And you'll see in hypothetical 1, we are dealing with a millennial family and a paternity dispute. And Yune, do you want to go ahead and talk through the facts of this hypothetical?
Sure. So we've got Frank, who's 25 years old, Mary, who's 24, and Paul, age 27. Mary and Frank are in an unmarried relationship, and it eventually deteriorates. However, Mary becomes pregnant by Frank, but she doesn't know at the time that she's pregnant with Frank's child, or her rebound relationship, which is the next relationship that comes after Frank with Paul. Then Mary's baby is born on time, and Frank seeks to assert his parental rights over the child. Well, Paul claims that he's the child's father, and a paternity case is filed in court. So let's discuss some of the legal issues involved with this scenario. First and foremost, paternity in this situation would have to be established. We know from the hypothetical that Frank is the child's father, biological father, not Paul. So Frank would need to file an action in court to establish his paternity, and sort of under the umbrella of that, they will also establish parental responsibility and decision-making over the child, and grant time sharing, order child support, and Paul essentially would have no legal rights to the child since he's not the biological father. And it's very important to note that in Florida, this action must be filed in order for even Frank, who's the bio dad, to have any legal rights to the child. So for the non-legal issues, you're going to have some issues regarding psychological effects, especially if the child has been brought up with Paul, or he's played a substantial role in the child's life. I mean, here we have a baby, but maybe there's a child that's 10 years old that has been, so to speak, kind of raised by Paul to some extent, and then Paul's just cut out of the picture. There's going to be some psychological issues there for Paul, and certainly for the child, that you'll want to address. Also between Mary and Frank, they're co-parenting, how they're going to, make decisions to raise the child. You'll have to deal with that. And there's a whole variety of issues, but I think we want to open it up now to some questions to the audience to see if you've got any questions on this scenario or any other part of the presentation.
And you may want to think about the 2 questions we're posing below. How might a family law attorney resolve this paternity dispute? And alternatively, how might a family mediator address the issues? So if anyone has some thoughts on that, we are eager to hear those, and you again can unmute yourself or place them in the chat.
If we don't have questions, I can answer them from my perspective. So as a family law attorney, a litigator resolving this dispute, you would first want to for sure have a DNA test done. Either the parties agree or it's ordered by the court to determine who the child's biological father is. Then you would move forward in establishing the rights for that biological father. In a mediator's perspective, maybe you definitely want to get the DNA test as well in that situation, or maybe you have it by the time it comes to you as the mediator. And then you can start thinking creatively about how these families can coexist and do what's in the best interest of the child or the children, whether that be mirroring the California third parent scenario or incorporating a more progressive approach in terms of allowing all the parties to have access to the children, and you'll want to identify boundaries and who's going to participate in what aspects of the child's life and things like that.
Yes, and as Yanae mentioned, here we may see in California, this could be a scenario where that third parent statute could be applied. So I'm just wondering if you have any thoughts, were that statute to be used, would it be successful in this case? If so, why? Or if not, why not?
Sarah?
Yes.
So there are, some of us are non-attorneys. I'm a therapist and a mediator. And if you can, because you talked about the third parent statute, can you briefly explain what that is for people
Yes.
who are non? Thank you.
Yes, of course. So that is something that was passed by the California legislature in 2013, when the court began to see a variety of new cases crop up in family court, where now a third adult wants to assert parental authority over a child. So this was a very novel issue for the courts, and they kept seeing more of these cases come through, particularly where there's an intact family. And by intact family, we mean these three parental figures are in agreement that they each want to have equal parental rights over the child. They each want to equally be involved, and there's no conflict between them. They're not vying for authority. They're not fighting amongst each other. They are all just in agreement and have now gone to court saying, we want to work together to help raise this child. So seeing that dynamic, the legislature passed that family code section 7612 at subsection C, which essentially states if you have three adult figures who are in agreement with raising the child, and the court would look at whether granting parental status is in the best interest of the child. If all of those are met, then the court will declare that third person a parent to that child. So you can see kind of the dynamics that are at play here. There's three adult figures who want to assert parental rights over the child. They're in agreement with their involvement. There's no other pending conflict. And so with those pieces in place, and knowing that it's going to be in the best interest of the child to declare three parents, the court can now apply the statute and grant the parental authority over the child. So here, compare that now with this hypothetical. We have a millennial family dynamic. We have a woman who has been with Frank and now Paul. Their relationships are not exactly clear because Mary has now rebounded with Paul. Is there conflict between Frank and Paul? Probably yes, because now he wants to assert he wants to declare himself the father as opposed to the biological father, who is the biological father. So we can see that there's probably some conflict that is cropping up. So in that scenario, can the court successfully apply that statute and declare Frank and Paul parents to this child?
So if Paul and Frank agree, basically the court won't have a problem.
If Paul and Frank agree, and there's evidence that declaring them all three parents will be in the best interest of this baby, then the court can declare it. But here's where you might see a mediator may be better equipped to handle this than an attorney, right?
Yeah.
So what are your thoughts on that? I'd love to hear either from you or others. If you now have this situation where there's conflict and the court can't cleanly apply the statute, what might you do as a mediator to help resolve it? And I see, go ahead.
Yes.
And then
Sorry,
Bruce.
this is Sonal again. So I think, there isn't a cookie cutter answer to this. What's important is to have a conversation, or to start a conversation with the three of them, separately, together, if they're ready to come together in the first place, in the same room, to have three people. But it's also important to do caucusing with the bio parents, as well as with Paul, who's now asserting his right as a dad. So a lot will come out of the conversation as to what went into it. And the reason why, excuse me, why Mary is not wanting Frank to get access. Is it only because he went away for a cooling period? So there are lots of scenarios that'll come out of it. And, we can spend a whole day talking of hypothetical scenarios that come out of it.
Yes.
But basically, to start a conversation, to find out why she's not allowing Frank, who's the bio dad, access to it. And then one other question that comes to my mind is that, so during the cool off period, she started seeing Paul. And let's say a year or two down the line, Paul moves out and, has a relationship with somebody else. So this is like setting off a chain reaction of various sorts. And so the three parent can tomorrow just become six parents if each one starts, kind of going out and having relationships and all. So this is kind of really complex, and more so I, as a therapist also, I think I'd like to have a conversation about the why and what is the guarantee that it won't happen. And then eventually to boil down to how the courts look at it and say that, okay, let's focus on the best interest of the child.
Yes.
So are we also saying that millennials are growing up with more moms and more dads? And is that becoming the new norm?
That is an excellent question. And right, and what defines a parent? Is it necessarily your biological parent, or a found family, for example? There are a lot of new nuances that are coming into play now, where not necessarily your biological parent is your only parent, right? We have other family members who often step into that role as well.
Sure.
And I think, Bruce, you had a comment as well.
I did. I'm used to working in teams when I mediate. Like, for instance, when I know the family law code has enough landmines in it that as a therapist, I could lead somebody astray unintentionally. But I also know most attorneys didn't spend that many years studying how to deal with emotions or child development. So there's a position that we have in our group, the neutral child specialist, who can, and now with an infant, it's a little bit different. I'm not particularly qualified to deal with infants. The youngest I usually have worked with is 4 or 5 years old, and teenagers. So with older children, if they're verbal or even nonverbal ways of communicating with them past infancy, you can bring a lot of information to the parents and be the voice of the children. If the child has a parental relationship with, I guess it's Paul, the person who's not the bio, but that's still a parent. It's a parent to him, it's a parent to the child. Without some way to incorporate that, you really make it risky for people to have relationships with people who have kids. I mean, nobody would ever want to take that risk if they knew somebody's going to come along later on and just kick them out of the picture. And it's really harmful for the child. And with an infant like this, I would want to bring in a child specialist who had background in babies and infants, and be able to share information with the parents that they wouldn't necessarily have themselves. And I don't know if I'm pronouncing it right, but Sonal, it looks like. I think she raised some really good points about wanting to have conversations with the parents and find out what the wherefore, the whys, the whats. Because one of the things they'd have to agree on with an infant is if the bio dad doesn't get time to spend with the baby, which might even include some overnights if they could work it out and he took the right parenting class if he didn't have those skills, then those bonds are not going to develop. And so then it'll be a difficult situation for a father who's asserting rights but doesn't really have that bonding connection other than their own interest. It's my child rather than what's good for the kid. And if they do get that connection, they're more likely to actually care about someone besides themselves, mainly the child, if that makes sense to you.
Yes, yes, excellent points. You brought up trying to bring in other professionals in a more collaborative approach, and I think that works really well with this scenario and the next scenario we'll be talking about. Lynette, do we have any other questions that came up in the chat?
Yes, and we have about 15 minutes left of time left, but there is one question that's related to this scenario. Can there be a third-party adoption, or is that not necessary?
I can answer that from the California perspective. Technically, yes, that's a possibility. Of course, that would be a petition in court. And the court would obviously weigh a variety of factors to determine if they want to grant that third-party adoption or not. Yanae, do you have any thoughts on that in terms of your experience in Florida's courts?
It's similar in the sense that, again, it would be a petition and it would be a step-parent adoption is what we call it. So in this case, Paul would be able to adopt the child as a step-parent if he is continuing a relationship with Mary. And it's very important, Frank would either have to agree to it or you'd have to prove certain things to terminate Frank's parental rights. That's the only way to achieve it.
We have a comment from Lucia, who's experienced the same exact scenario in one of her cases, and she would like to comment regarding the judge's perspective. Lucia?
Thanks, Lynette. I've had actually this exact scenario a few times. I was working up in Kern County, and the judges love when you can find a way to get these family dynamics to come to terms. I'm not an attorney. I was there specifically in the capacity as a family dynamics specialist and mediator. And I have found that if you can structure a visitation schedule in which all three parties feel comfortable, that's the first choice. The second is in some of the scenarios, because I also had guardianship cases, if it was discovered that one of the biological parents had maybe some challenging issues, such as maybe some addiction issues or whatnot. Sometimes the judges would lean towards the non-biological parent as being the lead. There's a lot of different components that have been discussed, but I just wanted to share that in so many cases, the judges preferred that if there was some way to get the entire family to agree to something that was supportive of the needs of the child, that's the direction that they'd like to go in. And so I just wanted to comment that even judges want to see families stay intact for the good of the child.
Yes, I think that's true widely in California. Is that true as well, Yanae, in Florida? That the judges want the parties to try to reach more amicable solutions outside of court?
Absolutely. In fact, before we get to a trial, we are required to attend a mediation and at least give it a shot to resolve a mediation. Yep.
And actually, one of the strategies we recommend is request that the court mandate mediation. And I know in California, we do have mandatory mediation now in child custody cases. So if a family comes into court wanting to resolve child custody issues, the judge will say, go to mediation first. There are either court mediators on staff, those are typically what's used in at least Orange County courts. The judge will send the parties out. There's already a mediator ready to help them work through the issues. Ideally, they will then draft up an agreement in terms of the child custody arrangements and present that to the court, rather than the court going through a full hearing on the issues. Sometimes the parties are referred to an outside mediator, but more often than not here, you have staff mediators in the court available to handle the mediation.
Sarah, can I say something? So I worked, I'm a mediator in private practice, but I also volunteer with an organization called Orange County Human Relations.
Yes.
As a family mediator. And we're in the Lamirau Justice Center. I mean, in the good old days, pre-pandemic, of course.
Yes.
And now we still did a couple of volunteer mediations, even online with some of the judges who forwarded us the cases. More often than not, what happens in the court mandated mediation is, and I think it's because of the restriction of time, they really don't get to say their piece. So we've had, when clients come to us, what happens is they've already been to court mandated mediation. So the outside mediation, so to speak, is not really in conflict with the court mandated mediation. And when you go to an outside mediator, what happens is that the scope of you really discussing in depth widens, and you're able to come to a solution, if at all, because of that. And so I think it's really very important that, cases like this, you are absolutely right, are more for mediators. And then, they collaborate with the attorneys to come up with the final agreement. So, thank you.
That's an excellent point. And you brought up the good point that even though we have this mandatory mediation model in courts, it can be time restrictive. And so there's not enough time to help the parties work through all these issues in a satisfactory way. And so, yes, they often do see a follow-up mediator to try to resolve the remainder of the issues. And so here, in terms of mediation, as I mentioned earlier, the goal is to focus on interests over positions to help the parties move towards a resolution more effectively, establish communication guidelines with the technological innovations that Yanae mentioned, and then knowing in the back of your mind that the law is not determinative, but background and education of the law is important, especially in these issues where you have California divorce law in the background, or parenting scenarios, or the third parent statute. Sometimes we need to be able to educate the parties on what the legal boundaries are so that they're knowledgeable, but not use that to guide the entire process. Do we have? Yes.
There's a question which I think, Sarah, you should answer, from Sully. If you can look at that, I think it's definitely worth.
Let's see. Lynette, can you read that up for me?
Sure. It says the case doesn't mention Paul's attitude to Frank's involvement. It looks like Mary needs to be informed of the law, which might help her adjust. Also, there are some more traditional cultures and some current populations where parenting is a lot more fluid.
That's a really good point. Other questions or comments before I move on to the next hypothetical?
So what is that question that she's asking of, that Mary needs to be informed about the law, which might help her? So the California law says no matter who you are, what you are, how you are, if you are the bio parent, you absolutely have to be involved.
So, and you can, was that Soleil who made that comment?
Yes.
Okay, and you can clarify, but what I'm getting from that is this is still based in a legal construct. And if we're thinking about California law and applying that statute, we as the advocate or the mediator, I think, have the responsibility to educate the parties of what would happen should this go to court. What might the judge be thinking about? What do we need to take into account? If we're thinking of applying that statute, the 7612, what might the judge be looking for? And so we would want to educate Mary as to the definition in that statute, that there needs to be agreement between the adults, that declaring the parent needs to be in the best interest of this baby. So that education is very important, not only for the parties' knowledge, but in terms of empowering them to make their own good decisions. A lot of the education piece in any of these family cases is about empowering the parties, not telling them what to do, but giving them information so they can make their own informed decisions.
Sure, thanks so much.
I have a question.
Yes.
So this is more about the court mandated mediation. And so mediation has widely been considered more of a voluntary process. And my question is, what do you think the effect is by having a lot of court mandated mediations, or that now being the standard, or requesting that being a standard? How do you think that affects the mediations that we have, or may affect it in the future?
This is such a good question, and I'd love for my mediation colleagues to weigh in on this as well. We know that mediation is quote unquote voluntary, but the court in many respects has taken the leap towards mandatory mediation in an effort to resolve these cases more expeditiously. That is for a variety of reasons, one of which the court calendar gets very compacted and crowded. And so the court is seeking ways to reroute these cases to other processes to resolve specifically the non-legal issues. But that has a psychological effect, right? Bruce, do you want to speak to that a little bit more? I know that you have a lot of experience in this arena.
Yes, I think that there really needs to be and I think this is a step towards it, a real public discussion on that, of trying to pretend that these kind of problems can be solved in a 1 or 2 hour meeting between people who have deep emotional reasons for their positioning. And, to think that just giving people information and they're always going to make rational decisions, well, if that worked, nobody would ever drive drunk. Nobody would ever get into a car after drinking. But it was only after Mothers Against Drunk Driving helped people reframe the position of drinking and driving. For instance, drunk drivers used to be portrayed as humorous characters in movies. Once they were defined in the public consciousness as threats to the people we love, suddenly they don't look funny. And if you see old movies with a drunk in it, it doesn't look funny at all. It looks really dangerous and bad. So I'm thinking an acknowledgement of the time and effort that it can take. The first meeting in mediation or therapy is often the people just deciding whether they feel comfortable even revealing anything to you. Mm-hmm. Another thing I find that most people don't ever talk about is a lot of times people will say yes to something, not because they agree to it, but as a pain control strategy. This is too painful. I can't bear to talk about it one more minute. I'll just say yes to get out of the meeting. But then that's not a durable agreement. And the whole reason for having mediation and consensual agreements is they take longer, but they're more durable. And so with a public conversation on what's the social cost of not investing in public mediators in the courts and giving them enough time to do it. I used to do in-home therapy with foster kids as part of my give back to the community. And I can tell you the social cost of not helping parents and giving them enough time and the resources to resolve these problems peacefully is really expensive in terms of the police power and prison power and things like that society has to invest into, because we don't deal with these problems in what I think is a realistic way. And I think sometimes the mediators in the courts know that people are just going to them and just checking the boxes. But it's really pretending to solve a problem, I think, that deserves a wider discussion.
Yeah, so you can see, Jared, this is more of a public policy discussion, which is much deeper than what we're going into for today's purposes. Jameson, did you have a comment? Go ahead and unmute yourself.
Thank you. I do think that's a great question. And from my indirect experience, I do HOA mediation, and partially I got into that because my dad is an HOA mediator and attorney. And my dad helped write the Davis-Sterling Act, which essentially part of it made it so that homeowner association disputes had to go to mediation before they went to court. So it doesn't force them to have a settlement, but it forced them to sit down. And that was one of the questions. The HOA kind of advocates in Sacramento were totally opposed to it. But over the last 15 years or so, it's shown that there's been great success, that people that didn't want to participate, now they look forward to it. The HOA kind of advocates and lobby love the Sterling Davis Act, or the mandatory mediation part of it. So I think having that so that people have to participate in the process, at least with HOAs, it's shown that it's been very successful.
That's an excellent point. And I think we're going to see that more often with these family cases, because it can be successful, and courts do want to push some of these cases outside of litigation. I know we have probably a lot of great other comments, but just for time's sake, let's go ahead and move to the next scenario here. Yanae, could you go through these facts?
Sure. So here we have Henry and Willa, who are the parents. There's 2 children, and then there's 2 sets of grandparents and an aunt. So the husband and wife are unmarried, and they're in a relationship with 2 children, ages 5 and 8. Both set of grandparents and aunt, which is the wife's sister, are involved in the child care for the children. and the husband and wife disagree over children's schooling. Conflict erupts and husband and wife separate. All the parties express different opinions. Husband and wife seek mediation and want what is best for the children.
Okay, here we can see now a whole family dispute where we now have that multi-generational dynamic coming up. So we now have the two parents who are unmarried, the grandparents who are of a different generation, and then an aunt. And now conflict has erupted over decisions regarding the children's schooling. And so hopefully you can see this is a potentially very complex issue and a complex family dynamic scenario with some legal concerns to consider as well as non-legal. So with the legal, of course, we have the declaring that the parents, so if they're not married, in California at least, you would have to file a petition in court establishing that you are the parent. So that would be step one. And then the second issue is who is going to be in charge of decisions regarding the children's schooling. So that raises a potential custody issue. Who has primary custody over the children? And still in California, we use the verbiage custody. And so those are your general legal issues. But in terms of non-legal, so here we have, again, many people who want to be involved in decision-making over the children and their schooling, etc. And so we have multiple opinions, diverse perspectives. And here we can see that there's potential for emotions to come up. The parents may feel very strongly in one direction, whereas the grandparents may feel strongly in the other direction. Emotions can escalate and tension can arise in that way. We also have the psychological aspect, which Yanae has touched on actually, where regardless of what kind of case, and here specifically, there are psychological elements to this where, you know, the parents still want to be involved equally in raising their children. They have now had a conflict which severed their relationship, but how can they still work together in the best interest of their children with that conflict still existing? So there's that psychological tension. And then perhaps that strain of the other family members now wanting input into the decisions as well. One set of grandparents has one opinion that children should go to private school. Another set says they should go to public school. So all these different tensions now, all these different opinions can kind of now be the cause of conflict escalating here. And so here with all these new dynamics, we want to think about, as a mediator, how are we going to address these dynamics that have arisen and the generational differences? And if we're thinking of our role as an advocate, what strategies might you employ as an attorney to resolve this outside of court? Because we know in this scenario, we probably want to encourage the parties to resolve it in mediation or some kind of collaborative approach, just because there's an inkling that they can possibly do it because the parents both want to do what's in the best interest of these children. And finally, touching on this collaborative aspect, how might an advocate or an attorney and a mediator collaborate to reach resolution? So a lot of potential issues here, a lot to discuss. This is definitely a more complex case. And in my practice, this type of case is what I see most of the time. So it's not the cut and dry family law case or probate case. It is these in-between cases where we have a variety of family dynamics going on, a variety of opinions left and right, and more non-legal issues as opposed to legal. And so I'm always asking myself, how am I going to help this family resolve the conflict and the issues in a way that's non-adversarial and in a way that minimizes court involvement? So assuming we can spend a little bit of time on this, I'd love to hear any comments regarding this scenario or any thoughts about this.
Sarah, Sonal again. So I have quite a few of these cases because I'm actually of Indian origin, my ethnicity. I was born in India, but I've been here for a very long time. So a lot of families are multi-generational in our culture,
Mhm.
where grandparents have a say. And to make matters worse, in our culture, it's the dad's parents who have a greatest say, and the mother's parents are not supposed to have a say.
Mhm.
So the whole the unfolding is that as a mediator, I literally am talking to each one of them, even separately. So I talk to grandparents separately, I talk to the couple separately, I talk to them individually to understand where each one is coming from. But at the end of the day, it's important to educate the older generation to
Yes.
say that the child actually belongs to these parents. So yeah, they add a lot of value to the child's life. But in the end, it's important for them to let the couple decide what they want for the children. They can talk to the couples, but you cannot enforce your decisions. And so this is a conversation, this is over a lot of sessions with
Yes.
different parties and and it's very important to talk to them solo, because so much comes out in that individual session of yours. As you build trust with them, you come to know their issues and where they're coming from, and then you kind of put all the pieces together, and the crux then finally comes to asking the parents, what is it that they really want for their children,
Mhm.
irrespective. So if the parents were not in this, laying out a hypothetical scenario to say that if your parents were not in the picture, what is it, how would you have decided this, or what would you have done? And so that's where you kind of take from, because that's where your desire comes out to say, I really, really wanted my child, I would want my child to go into this private school, and these are the reasons. And then the husband will, in your individual session, come, or the father will come and say, I understand, but I have a financial issue, and she doesn't understand, but he's not telling that to the wife or
Mhm.
to the partner. And so there are these all intertwined things, and just as you keep untying the knots, I think the solution kind of emerges from there.
Excellent points. And a lot of what I've heard in your response was opening the channels of communication and asking the parties what they actually want the result to be. So again, it's that empowerment piece.
Yeah, and also just one thing, with complete due respect, and I have
Sarah,
a lot of,
I have a comment.
Is that okay, Sanal?
yeah, go ahead. Let her talk.
Oh, all I was going to say is I kind of have the opposite approach. I always have all the families together, and in many cases, the grandparents decide to, file for guardianship. And there may not even be a quote valid reason. They just decide they don't like that the daughter lives in an apartment, or that the spouse is just in and out of the lives. And so I'm not an attorney, but from another viewpoint, if they start to apply for guardianship and then the parents counter, they oppose, then there's that dynamic going on too. And in my experience, sometimes it has absolutely nothing to do with the child. The grandparents don't like the husband for whatever their reasons, or decide that their own daughter is not capable of raising their child for a variety of reasons. And so I find that always very interesting, that just within that small unit, everybody is starting to finger point, and that it's all about like and feeling rather than maybe any legal standing. And so the reason I have them all in the room together is usually as the conversation continues, the viewpoints of what concerns the grandparents versus what concerns the parents gets kind of filtered out. And I notice when they go back and forth, we kind of bring the temperature down. That's kind of my rule. The temperature has to go down. And then they start to find little snippets that they have in common. And so I'll start to tell them, oh, look, that's an agreement. And then they start to be more amicable, that maybe there's other layers. I know I mentioned a lot before, visitation is huge too. If the families don't live within the same household, sometimes knowing that they have enough time with the children can be enough to bring a little bit more harmony to the family dynamic. But I heard you mention, Sarah, that you sometimes do probate, and I know that kind of throws a monkey wrench in when somebody decides to apply for guardianship.
Oh gosh, that's right. So we see these issues magnify significantly in probate cases. So it's it's an interesting dynamic that often comes up, and using the same strategies you mentioned, Lucia, in terms of the communication, speaking with everyone in the room, honoring and trying to reach agreements, etc., and seeing all these little issues and potential suspicions coming up, which is often a common dynamic in probate cases. Before I move on to strategies, Yanae, do you see any similar strategies or similar issues in your practice area in Florida in terms of these types of cases?
I do actually. We have a very large Latin community down here in South Florida. So it's kind of similar in the sense that there's a lot of people involved in the children's lives that care about them, you know, family members included, grandparents, aunts, uncles, cousins, even, that want to really be involved. And unfortunately, our courts don't allow for that. Our laws don't allow for those other parties to have rights. So in a situation like this, I always encourage them to attend mediation and see if they can resolve to be inclusive of all those family members, because what could be better than all of these people wanting to be involved in a child's life and loving them and nurturing them? So, yeah.
Yep, that's beautifully said. I'm getting to strategies here, and many of you have touched on these already. So bringing back this idea that in these cases now where we have millennial families as well as multi-generational, we do see now multiple interests at stake. Family dynamics are different in terms of family structures and the way people are communicating and relating to each other, various issues, and then the law in the background. So here are some strategies, and I think we have touched on these throughout this presentation. Allow the parties to be heard, and we've heard that a couple of times, where we are encouraging open communication, where we are providing the parties access to technology, for example, to enhance communication, and we are encouraging them to be their own conflict resolvers. We're empowering them to make their own decisions and empowering them to have their voice be heard. We are identifying common ground and common interests. So remember, I mentioned before that often there's a surface level issue, which is the legal issue more often than not, but there's always an underlying issue, which is more of an interest. So in the scenarios we've discussed, one interest may be safety of the children, a safe home environment, a good place for the children to go to school. So, and there are a variety of other interests, but focusing on the interest rather than the actual legal issue or the position, in order to get the parties on the path towards resolution. And as I mentioned earlier as well, being flexible and adaptable in your approach. So whether you're an advocate or a mediator, being able to be flexible in your process and how you reach the parties and how you communicate, and in terms of the strategies you use to help them resolve the conflict. And adaptability. With these multi-generational families where you have the older generation and the younger generation, you may need to take more breaks in mediation session. You may need to do sessions over multiple days. You may need to do some sessions remotely via Zoom. You may need to do some sessions via phone. So being able to adapt to the scenario and to the needs of the parties as necessary. And one important one here below is acknowledge the conflict, but look forward. And I know many of you here are very skilled at doing that, where we want to help the parties move forward. We want to acknowledge that they've gone through difficult times, but our ultimate goal is to help them come to an agreement or resolution, to avoid court to the extent possible, and look forward or future looking. And finally, to recognize progress and document plans. So this goes back to the planning aspect. So whenever the parties have reached an agreement, we want to recognize that as a way to encourage them to continue doing that. And a lot of this is modeling on our part. So as the guide in the room that's guiding them towards resolution, we want to show that, you know, we should recognize progress, and we want to celebrate that and really document the progress as we go along. That's important for the parties in terms of them sustaining the session. It's also important if you are going to be returning to court with that agreement. Make sure you have that documented so that you have the parties' overall agreement in writing so that you can then move forward more successfully. Any other comments and questions? I know that was a lot of material that we just covered, and I know we went through that last portion somewhat quickly. And Lynette, could you check the chat once again for me?
There are no further comments or questions.
Okay.
And we did go over about 15 minutes, but we could talk about these issues for another hour.
Yes.
Yep.
So if there are any further comments or questions, we can take maybe a couple of them really briefly. And if not, then I think this concludes our presentation. Thank you, Sarah and Yane, very much for the presentation. We had some great comments and questions. And this concludes our program on modern love, innovations in how we address family conflict. Brown Bag Networking Lunch is going on right now until 12:30. So feel free to sign out and then use the link to sign into the networking lunch. And please join us for the afternoon session, which begins at 12:30.
Lynette, are you going to share this presentation with us, the PowerPoint with the people who attended?
So if I'm not mistaken, this should be available to you once the recordings go out.
Oh, okay. All right. Thanks so much. Yeah. Thanks, Sarah. That was really helpful.
Oh, good. And just a reminder, if you have other comments or questions in regard to our presentation, feel free to contact us at our email addresses.
And also, I just wanted to add it again, if you still need to provide us with your state bar numbers, please email us at info@scmediation.org. Thank you.